The House of Representatives has already passed it. The Senate is set to bring it to a vote. If it passes, it goes to the president's desk and becomes the law of the land. And if that happens, Congress will have passed a bill that will almost assuredly strip American citizens of their right to vote, not by targeting non-citizens, but by building a system where the safest thing an election official can do is tell you no, where a database error you've never seen and can't correct can erase 20 years of voting history, where your federally approved ID, the one you stood in line to get, the one that got you through the airport, isn't enough, where the information of every registered voter in America gets sent to the Department of Homeland Security within 30 days of it becoming law, and where the rules that actually govern all of this get written after the vote by a commission most members of Congress couldn't name, and most Americans have probably never heard of. This isn't about election integrity. This is about what happens when you build a law that presumes every American citizen is a suspect until the government says otherwise. This is the SAVE Act. If any of what you're about to hear concerns you, I urge you to share this with others, and especially with your senators or anyone you know who works for a senator. Because right now, the Senate is the only thing in the way of it becoming reality. The lawsuit trap. To understand one of the most consequential pieces of the SAVE Act, you need to understand a law that's been protecting your rights to vote since 1993, the National Voter Registration Act. The NVRA was designed to make voter registration more accessible. It's the reason you could register to vote at the DMV. It's the reason public assistance offices have to offer voter registration. And buried in that law is something called a private right of action. That's the legal mechanism that lets an individual citizen sue if an election official wrongfully denies or mishandles their voter registration. You are entitled to register. And if an official blocked you, you can take them to court. That's the NVRA's private right of action, a shield for voters against officials who abuse their power. The SAVE Act keeps that language. It just rewrites its meaning. Under the SAVE Act, that same private right of action gets amended to allow any individual or any group, which means any political organization, any corporate-backed advocacy group, any well-funded outside interest, to sue an election official who registers someone without the required documentary proof of citizenship. The official doesn't even have to have done anything corruptly. They don't have to have known that the person wasn't a citizen. They just have to have made a judgment call that someone can later claim was wrong. And now they're facing a lawsuit. And it doesn't stop there. Sitting right next to that private right of action in the bill is a criminal penalty provision. An election official who registers someone without the required documents faces up to 5 years in federal prison. Civil lawsuit on one side, criminal prosecution on the other. And in the middle is the election worker who has to decide in real time whether the person in front of them has proved their citizenship sufficiently. If you're that official, what's your incentive? Approving someone that puts you at legal risk? And denying someone, even someone who is absolutely a citizen and has every right to register, costs you nothing. The entire structure of the law pushes in one direction. When in doubt, reject. This isn't a hypothetical. We don't have to guess what happens when officials operate under that kind of pressure. Kansas implemented a state-level proof of citizenship requirement under then Secretary of State Chris Kobach. The result ended up in federal court. And what did the court find? Over 31,000 eligible American citizens had been blocked from registering to vote. Not non-citizens, citizens. People had every legal right to cast a ballot, caught in a system that was built to punish the wrong call in one direction and ignore the wrong call in the other. And then there's Iowa. And this one matters because it happened in 2024, without any federal law requiring it and without private lawsuits threatening anyone. Just before the presidential election, Iowa officials compiled a list of roughly 2,100 voter registrations to scrutinize for potential non-citizen status. The list was based on old Department of Transportation records. The problem was that data was outdated. And when the dust settled, at least 500 people on that list were confirmed to be citizens. Now ask yourself, what happens when you take that same dynamic and supercharge it with a federal law that lets outside political groups sue election officials personally? What happens when you add up to 5 years in prison as a consequence for the official who makes the wrong call on a borderline application? You don't get more careful, precise screening. You get the Iowa situation, except in every state, in every county, in every registration cycle, because every official in the country is now running the same calculation Iowa's officials were running. And the math always comes out the same way. The NVRA's private right of action was a shield. It existed so that when the system failed a voter, that voter had recourse. The SAVE Act takes that shield, flips it around, and turns it into a weapon, not against non-citizens, but against the officials whose job it is to register eligible American voters. And when you make it dangerous to say yes, officials stop saying yes, even when they should say yes. And the people who pay the price aren't the non-citizens this law claims to be targeting. They're the citizens it was never supposed to touch. How the SAVE Act can erase your vote before you ever cast it. Here's a scenario. You've been registered to vote for 20 years. You've voted in every election. You've never had a problem. And then one day, without a letter, without a phone call, without any notice whatsoever, your name is quietly removed from the voter rolls. You don't know what happened. The first time you find out is when you walk into your polling place on election day, and the person at the table looks up at you and says, "You're not registered." Under the SAVE Act, that is not a hypothetical. That's one of its features. The SAVE Act requires states to run their existing voter rolls through a series of databases to identify supposed non-citizens and remove them. And the bill is very clear about what happens when a match comes back. It says a state shall remove a registrant at any time upon receipt of documentation or verified information that someone is not a citizen. Shall remove, not shall investigate, not shall notify the voter and give them a chance to respond. Shall remove. And in that broader removal pathway, there is no express requirement to tell the voter before it happens. To be fair, there is one narrow pathway in the bill, the route through the DHS verification system, where some notice language exists. But the bill doesn't create just one single pathway to remove voters from rolls. It creates multiple. And the broader command, the one that says remove upon receipt of verified information, doesn't carry that same protection. So what you end up with is a law where whether you get warned before losing your right to vote depends entirely on which database happened to flag you. That's not a safeguard. It's a coin flip. But the notice problem is only half of it. The other half is the databases themselves. The bill identifies several sources states can use to run these checks. There's the DHS SAVE system, which has nothing to do with the SAVE Act, by the way, but more on that later. There's Social Security Administration data. There are state driver's license and ID records. Each of those has its own documented problems. But then the bill adds a fourth category. And this is the one that should make every American pay attention. Category D, other sources, including databases, which provide confirmation of United States citizenship status. That's it. That's the whole category. Other sources, including databases. No requirement that they be government records. No requirement that they be verified public data. No requirement that the citizen whose name appears in them has any right to see what's there, challenge what's wrong, or even know they exist. If a state can get its hands on a database that claims to say something about citizenship status, the SAVE Act opens the door to using it. And we know exactly what happens when government uses that kind of open-ended database authority, because we've already lived through it in another context. Since 2018, the Social Security Administration has used a private database, a commercial product from LexisNexis. They use this to identify whether people receiving SSI disability and elderly benefits own unreported property that could disqualify them. Thousands of extremely low-income elderly and disabled Americans had their benefits cut off based on matches that were wrong. If someone with your name owned property somewhere in the country, you could be flagged. And when you were flagged, the burden fell on you to correct it. Prove you don't own this property. That's the template the SAVE Act imports into voting. And we don't even have to speculate about those name databases and what they'll do, because we already have the evidence. The DHS SAVE system, the primary tool the bill requires, has already been deployed in several states, and the results have been alarming. In Missouri, officials acted on SAVE's findings before verifying them, directing county administrators to block flagged voters from casting ballots. More than half of those flagged in one Missouri county turned out to be citizens. In Texas, a quarter of the voters flagged as potential non-citizens in Travis County had already provided proof of citizenship when they registered. DHS itself had to go back and correct information it had sent to at least 5 states after the system got it wrong. By the way, the SAVE system errors in Texas and Missouri didn't happen because those states passed a SAVE Act-style law. They happened because the executive branch pressured states to use the system through an executive order that was stopped via an injunction for being unconstitutional. And even under that limited optional deployment, the errors were severe enough that DHS had to go back and correct data it had sent to multiple states. The SAVE Act would take that same flawed, error-prone system and make it mandatory for all 50 states. State driver's license records have their own well-documented history of failure. They capture your status at the time of a past DMV transaction, not whether you later became a citizen. That's what happened in Texas. The state flagged over 95,000 registered voters as potential non-citizens based on DPS data. and then had to acknowledge that thousands of those people were actually citizens whose records reflected an earlier immigration status that had never been updated in the system. So pulling this all together, the SAVE Act creates a system where states are required to run every existing registered voter through a series of databases, and then remove anyone flagged as a non-citizen. One removal pathway has some notice attached, another one does not. And the catch-all category in the bill leaves the door open to private data products that the flagged citizen can inspect, can't challenge, and in some cases has no legal right to even see. 20 years of registration, 20 years of voting could be gone simply because the database got it wrong. The undefined standard. There's a legal principle so basic that most people take it for granted. If the government is going to take something from you, your benefits, your job, your freedom, your right to vote, the standard for doing so should be clear. You should be able to look at the law, understand what the government needs to show, and know whether it has actually shown it. That principle isn't just fairness, it's the foundation of due process. The SAVE Act throws that principle out the window. Here's what the bill actually does. When it comes to proving you're a citizen to get registered in the first place, the bill is meticulous. It lists specific documents, a passport, a birth certificate paired with a photo ID, a naturalization certificate. It spells out exactly what counts. You could read the list and know whether you have what you need. But then the bill turns around and addresses the other side of the equation, what it takes for the government to remove a registered voter from the rolls. And then the precision disappears entirely. The bill says a state shall remove a registrant upon receipt of documentation or verified information that the registrant is not a United States citizen. That's it. The bill never defines that phrase, however. It doesn't specify how many data points need to match. It doesn't require a unique identifier. It doesn't prohibit name-only matching. It doesn't establish a hierarchy of evidence, meaning there's nothing in the law that says a voter's existing registration or their previously submitted proof of citizenship outranks a database hit. It just says verified information and leaves every state to figure out on its own what that means. Could a first and last name match in an immigration database be enough? The honest answer? The bill doesn't say, but it also doesn't say that it isn't. We know what name-only matching produces in practice because we've watched it play out in other high-stakes contexts. The Supreme Court addressed this directly in the 2021 case TransUnion LLC versus Ramirez. A company was checking people's names against the Treasury Department's sanctions list, a list of people designated as suspected terrorists, drug lords, and criminals. The system compared first and last names, nothing else. The court noted this approach unsurprisingly generated a large number of false positives because thousands of law-abiding Americans share first and last names with people on that list. One man was denied the ability to buy a car because his name matched a name on the sanctions list. He was not the person on the list. He just had the same name. That's what happens when a name match gets treated as verified. Now apply that to voter rolls. There are roughly 330 million people in this country, and among them are so many common names. Jose Garcia, Maria Rodriguez, James Williams, and they're all shared by tens of thousands of Americans. A database that flags a registered voter because their name appears somewhere in the immigration record isn't verifying identity. It's pattern matching against a population. And the SAVE Act doesn't draw any line between those two. But there's another layer to this that makes the problem even worse. And it involves the election official caught in the middle. The SAVE Act doesn't eliminate official discretion. It does something more dangerous. It mandates discretion, and then it punishes officials for exercising it in one direction. What this law is actually doing is putting the onus of the state election official to decide whether or not you are a citizen. Imagine a state official making the determination that you are or are not a United States citizen. The ID that doesn't work. After September 11, 2001, Congress decided the country needed a standardized, secure form of identification. The result, passed in 2005, was the Real ID Act. The idea was straightforward. Set minimum federal standards for state-issued driver's licenses, verify that applicants are who they say they are, confirm they're lawfully present in the United States, and create an ID the federal government could trust. It took years to implement. States had to overhaul their systems. Millions of Americans stood in lines at the DMV, dug out birth certificates and Social Security cards, and went through the process of getting a Real ID-compliant license. As of 2025, you need one to board a domestic flight. Most Americans now look at that gold or black star on the corner of their driver's license and reasonably believe they have the gold standard of government-issued identification. A federally compliant ID, the kind the government trusts. Under the SAVE Act, in 45 states, it's not enough to register to vote. The SAVE Act says a Real ID can serve as proof of citizenship, but only if it indicates that the holder is a United States citizen. That one phrase, indicates citizenship, is where the entire argument collapses, because Real ID was never designed to indicate citizenship. It was designed to verify identity and confirm lawful presence in the United States. And lawful presence is not the same thing as citizenship. Think about who lawfully present includes. Green card holders are lawfully present. Refugees are lawfully present. People on work visas are lawfully present. All of them can obtain a Real ID compliant driver's license. Real ID confirms you are who you say you are and that you're legally here. It was never built to tell you which category of legally here you fell into. So when the SAVE Act says a Real ID works only if it indicates citizenship, it's describing a function that the standard Real ID card in 45 states simply doesn't perform. Only a few states issue what are called enhanced driver's licenses. This is a version of the ID that does verify citizenship and would likely satisfy the SAVE Act's requirements. But those are only a few. So odds are, if this bill passes into law, then the ID in your pocket is probably not going to work. But there's another layer to this. When someone can't produce the physical documents, when the passport isn't available, the birth certificate doesn't match the name, what does the system fall back on? Databases. The same DHS SAVE system that has already misidentified citizens as non-citizens in Missouri, Texas, and Alabama. The Real ID failure is not an isolated problem. It's a funnel. It takes the millions of Americans whose standard Real IDs won't satisfy the bill's citizenship requirements and routes them directly into a verification system built on databases we already know are broken. This is for everybody. There's something in the SAVE Act that almost nobody is talking about. Not a buried footnote, not an obscure technical provision. Something that would happen within 30 days of the bill becoming law, affecting every single person registered to vote in the United States of America. Within 30 days of enactment, every state must submit each individual on its official list of eligible voters for federal elections to the Department of Homeland Security for citizenship verification. Not the suspicious ones, not a random sample, not the people who triggered a flag in a database somewhere. Every registered voter. Every name on every state's official federal election voter roll sent to DHS within a month of this bill being signed. Most people, when they hear about the SAVE Act, think of it as a voter registration law, something that affects new registrations going forward. And that's in there, we talked about it, but it's also something much larger than that. And this provision is the part that most people completely miss. If you are registered to vote right now, if your name is on the rolls today, your information would go to the Department of Homeland Security within 30 days of this bill becoming law. No action required on your part. No notice sent to you. It just happens. The state sends a list. Your name is on the list. DHS receives it. Now you might be thinking, sent to DHS to run through what exactly? And this is where the story gets genuinely interesting. Well, if it hasn't already been interesting. Because the bill doesn't create a new system for this. It plugs into an existing one. And the name of that existing system is almost certainly not what you think it is. The bill that Congress passed is called the Safeguard American Voter Eligibility Act, the SAVE Act. And the database it requires states to use? It's called SAVE. But these two SAVEs are not the same thing. They are not related. They just share an acronym. The database is the Systematic Alien Verification for Entitlements. That's what SAVE stands for when you're talking about the system at DHS. Two entirely different programs. Same four letters. And unless you're reading the fine print, you'd never know they weren't the same thing. So what is the Systematic Alien Verification for Entitlements? And why does it matter that this is the system being used? It was created in 1986 under the Immigration Reform and Control Act, signed into law by President Ronald Reagan. At that time, Congress had just restricted access to certain federal benefit programs like Medicaid and aid to families with dependent children, and they were restricted to citizens and legal permanent residents. But the government needed a way to check whether non-citizens applying for those benefits were here legally, so it built a system. That other SAVE, which is the database, a welfare eligibility screening tool for checking immigration status. That is what this system was designed to do. That was its origin. That is what it was built for. It was not designed to be a national voter citizen registry. It was not built to verify the citizenship status of 160 million registered American voters. If this bill comes into law, this would be a permanent ongoing federal pipeline from every state voter roll directly into the Department of Homeland Security, with no restrictions in the bill on what DHS can or can't do with that information once it arrives. So let that settle in for a moment. The bill places no limits on the federal government's use of your voter registration data. No restrictions on who at DHS can access it. No prohibition on sharing it with other agencies. No requirement that it be deleted after verification is complete. Your name, your address, your registration information, transmitted to the Department of Homeland Security by law, with no guardrails on what happens next. And maybe even more information, because we have no idea what batched information really means. Over 200 years. There is a principle so fundamental to the American idea that most of us never think about it consciously. We just feel it. It's woven into the way this country was designed to work, into the relationship between the citizen and the government, into the basic understanding of what it means to live in a free republic. You are innocent until proven guilty. The burden of proof in America belongs to the government, not you. If the state wants to take something from you, your freedom, your property, your rights, it has to make its case. It has to show evidence. It has to meet a standard. You don't walk into a courtroom and prove you didn't do something. The state has to prove you did. That principle didn't come from a statute. It didn't come from a regulation. It is embedded in the DNA of this country, in the due process guarantees of the Constitution, in 200 years of American law and practice and value. The SAVE Act throws that principle out. Under the SAVE Act, your citizenship is not presumed. It is suspect. You are not a verified American voter until the government says you are. And if a database somewhere, a database you've never seen, maintained by agencies you've never interacted with, possibly assembled from data you have no right to inspect or correct, says something that calls your citizenship into question, the burden falls on you to prove the database wrong. Not on the government to prove it right, on you. Think about what this means in practice. You've lived in this country your entire life. You were born here. You have voted in every election since you turned 18. And one day, because a record somewhere has your name slightly wrong, or because a DMV database from 20 years ago never got updated when you naturalized, or because a commercial data broker sold the state a file with an error in it, a flag appears next to your name. And now you have to prove you are who you say you are, to a standard the law doesn't define, using documents that millions of Americans don't have, to an official who faces personal legal consequences for accepting your proof and nothing at all for rejecting it. That is not the American system. That is the inversion of it. But there's another part, a part that makes this especially dangerous. It's not just that the burden shifts to the citizen, it's that the executive branch controls most of the machinery that determines what counts as evidence against you. The databases that feed the verification systems are federal databases, mostly, controlled by federal agencies, administered under the authority of whoever happens to be running the executive branch at any given moment. The standards for what counts as verified information, sufficient to remove you from the rolls, are not defined in the statute. They are effectively set by whoever controls DHS. The information those federal agencies provide to state election officials, the inputs that drive the decisions about who stays registered and who gets removed, flows from Washington under the control of the administration in power, with no statutory floor defining how reliable it must be or what quality of match is sufficient. And then, as we have discussed throughout these sections, that information lands in the hands of state officials who face civil lawsuits and criminal penalties if they accept a registration they shouldn't have, or at least someone says they shouldn't have, and they suffer nothing if they deny one they should have accepted. The federal government controls the evidence. The structure of the law rewards denial. The citizen bears the burden of disproving whatever the system decides to say about them. So many bills. One clarification before we close. You may have heard two names thrown around, the SAVE Act and the Save America Act. They are largely the same bill. The Save America Act is the version that passed the House in February 2026. The original SAVE Act passed the House in 2025. The core framework is identical in both. The proof of citizenship requirements, the private right of action, the database purges, the DHS pipeline, all of it. The one significant addition in the Save America Act is a strict photo ID requirement for voting at the polls, which goes beyond what the original SAVE Act contained. Everything we covered in this episode applies to both bills, because the Save America Act is built on the same foundation as the original. The photo ID provisions are a separate and serious problem in their own right, but that will be covered in a future episode. For now, it's important to understand that what we walk through today is the baseline, and the baseline alone is enough to tell you what kind of law this is. The commission nobody's heard of. Everything we have talked about in these sections, the lawsuit trap, the purge machine, the undefined standards, the broken databases, the real ID failure, the DHS surveillance pipeline, the reversal of 2 centuries of American principle and rights. Those are all things that, well, Congress should know, but I'm not entirely convinced they do. Regardless, there is something that I know that they do not know and can't possibly know, because the bill technically isn't complete when it goes into law. The part that gets written, the part that operationalizes it, the part that tells the election officials at the state level what to do, that comes after it becomes law. It leaves some of the most consequential questions about who gets to vote and who doesn't, about what counts as proof and what doesn't, about what standard an election official must meet to register someone whose documents don't quite fit the list. It leaves all those questions to be answered later by a commission that most Americans have never heard of, the U.S. Election Assistance Commission. It was created in 2002 by the Help America Vote Act, passed in the aftermath of the Florida recount disaster when Congress decided the country needed some federal support and guidance for election administration. Now, HAVA in the 2000 election, they're going to get their own episodes later. Trust me. For now, we're going to focus on this. The EAC is an independent, bipartisan commission. Its 4 members are appointed by the President and confirmed by the Senate. It maintains the National Mail Voter Registration Form. It develops guidance for states on how to administer elections. It certifies voting equipment. It is, by design, a support agency, not a rulemaking body with broad authority to compel states to act. Its rulemaking power is explicitly limited by federal law. That is what the EAC is on any normal day. Under the SAVE Act, the EAC becomes something else entirely. Once the bill becomes law, the EAC must define the minimum standards required for a state official to register an applicant who cannot provide the listed documentary proof of citizenship. It must create the affidavit form that officials must sign when they approve a registration based on alternative evidence. It must develop guidance on how discrepancies in documentation should be handled. It must tell every state election official in the country what the rules actually are, because the bill itself doesn't fully tell them. And the bill requires the EAC to do all of this: write the rules, design the forms, create the standards, and transmit guidance to the chief election official of every state in America within 10 days. Not 10 months, not 10 weeks, 10 days from the moment the president signs the bill into law. The EAC must have produced and distributed the implementation framework that will determine, in practice, whether millions of American citizens can exercise their constitutional right to vote. There is no phase-in period. There is no public comment requirement. In fact, the bill goes out of its way to waive the Paperwork Reduction Act, one of the primary federal mechanisms through which ordinary Americans get to weigh in on new government information requirements. The normal process for public input doesn't apply. The EAC writes the rules go out, and the country lives with them. Think about what this actually means. The questions that matter most in this entire law: what alternative evidence is sufficient to prove citizenship, what the minimum standard is for an official to exercise judgment, what goes in the affidavit, how discrepancies get resolved. None of those questions have answers written into the statute. Congress doesn't get to debate them. They are delegated to 4 presidentially appointed commissioners operating under a 10-day deadline with no congressional vote on what they decide and no public comment period required. It's still in the Senate. It still can be stopped. So that is the SAVE Act and most of the Save America Act. But regardless of what they want to call it, if it passes, it will be a purge machine. I hope you found this informative. And if you have, please like, comment, and share.